Good morning, everybody. Welcome to the hearing this morning. My name is John Baza, and I am the Director of the Division of Oil, Gas, and Mining. I will be acting as the presiding officer in this matter. This is an informal adjudicative proceeding, which I may refer to as conference or hearing. The matter concerns a revision Geneva Rock Products Inc. submitted to their notice of intention to commence large mining operations, division file number M/035/0026. The sole purpose of this conference is to hear argument from Geneva, Draper, the division, and those individuals who submitted written objections of substance and reserved a spot to participate in this conference. The issue and arguments raised should be aimed at assisting a presiding officer to make an informed decision concerning Geneva's requested revision. Seated next to me is Mr. Trevor Gruel, who is my counsel in this matter. The division has separate counsel. We also have a court reporter who is transcribing this hearing for us, and we are also broadcasting the hearing on YouTube for the public. We recognize and appreciate the serious public interest in this permit process. In accordance with relevant laws and regulations, notice of Geneva's requested revision was publicized and public comment was received. Some of the public comment received has been determined to be written objections of substance. Participation in this conference will be limited to those who have previously submitted a written objection of substance and reserved their spot, as well as the three parties who have filings of record. Because the time for public comment in this matter has already closed, there will not be general public comment at the conference today. For those in attendance today, please remember that everyone is expected to behave in a professional and respectful manner. We want to try to do this as efficiently as possible and receive pertinent comments and information that will help the division in its process. I will not tolerate behavior from anyone who threatens to disrupt the orderly progression of the conference process or intimidates or harasses those who are participating. Anyone who cannot conduct themselves appropriately will be asked to leave. The conference will follow this order. Geneva will present first. They will have the opportunity to discuss their position on whether they have met the requirements of the statute and rules. Geneva will be allocated 30 minutes and may reserve some of its time to rebut issues raised during the course of the conference. Next, Draper will present why it believes Geneva has not met the requirements of the statute and rules. Draper will have 20 minutes. Following Draper, any of the individuals who submitted written objections of substance and reserved a spot to participate in this conference will be allowed to participate. Each individual will have approximately 3 minutes to raise substantive issues they have with Geneva's requested revision. For this purpose, a separate podium and microphone has been set up. If you do come up to speak at the podium, please remember to turn the microphone on by pressing the button, and a green light should appear on the microphone. We will then hear from the division, which will provide any information it considers to be relevant. Finally, Geneva will have the opportunity to address or rebut any issues raised by the objectors or the division. Mr. Gruel will be keeping track of time and will let you know when you have used your time allotment. I do not intend to issue a decision today. We will take this under advisement, but at the close of the hearing, I will take the matter under advisement and issue a decision in the order in the next few weeks. Before we begin, I would ask those participating to avoid duplicative arguments if possible. If you notice that the issue you plan on raising has been covered by another presenter, please consider summarizing or removing that particular point. However, we want to give you an appropriate time to voice your opinion. So are there any questions or of those presenting today? And if you have a question, if you'd please state your name for the record. I do not see any, so maybe we ought to take appearances of counsel for the three parties I've mentioned. Geneva first.
Thank you, Director Baza. My name is Cass Wallen. I'm an attorney with Parr Brown, Gee & Lovelace. I'm representing Geneva Rock Products today. With me here is Justin Matkin, a partner at Parr Brown.
Thank you. For Draper.
Thank you. I'm Maria Wyndham of the law firm of Ray, Quinney & Nebeker for Draper City. With me is Mike Barker of Draper City.
Thank you. Division.
Thank you. Elizabeth Harris with the Attorney General's Office. I represent the Division of Oil, Gas, and Mining, and with me is Dana Dean, the Deputy Director of the Mining Program.
Thank you. So I think we can go forward at this point since there are no questions. Counsel for Geneva, you may proceed, or if you want to defer your presentation, I'll let you do that as well.
Thank you, Director Baza. I don't think we'll need a full 30 minutes here, but I did want to mention a few things just to get us started. And I wanted to thank the division, thank the commenters in Draper City for their participation in this important public process. I wanted to give a little background on this site and this project. As we know, this mining use is located at the south end of the Salt Lake Valley. It's existed for many, many decades. It provides crucial public infrastructure material that's used in roads and schools and other important public infrastructure projects. The geology at the site, it consists of highly fractured bedrock material intermixed with alluvial deposits, and that has been the case throughout the history of the project, and the record in the division's files reflects that in many different documents. Before this site was permitted by DOGM, Geneva and its predecessors were mining there. In 2004, the division approached Geneva and said, Geneva, we need you to submit a notice of intention to commence mining operations. You're operating in bedrock material and we have jurisdiction over that bedrock material. And so Geneva complied with that instruction. They immediately posted an interim bond and followed that up with a submission of a notice of intention that was later approved by the division. And for more than a decade, Geneva has been operating under that permission from the division. I want to show a map here. And this is the original map that was submitted with the original approval. It was approved in 2009, in March of 2009. You'll notice here that the blue line, it's somewhat faint, but the blue line represents the permit boundary. And you can see that it extends out to the east and also onto the west. It continues on further westward, but is not included in this particular shot. Excuse me. I'm on D. This is the one that's in 2009, approved in March of 2009. The one I had up is a later. We'll get to that in a minute. But the red line on this map shows the 486 acres of property, and it doesn't show all 486 acres, but includes this main portion here that's on the east side of the freeway. And then on the west side of the freeway, there's several acres, 100 acres on the west side of the freeway. That entire area was reviewed in 2009, well, between 2005 and 2009 by the division in cooperation with Geneva. There were many discussions about the requirements of the permit. But this entire area was studied and reviewed because it was identified as the permitted area, the permit area boundary as it's labeled on the map. But Geneva committed to conduct its active mining operations only within the area that's labeled Phase 1. And you'll see a faint blue line that demarcates the easternmost edge of that Phase 1. And Phase 1 also included area on the west side of the freeway. In total, that Phase 1 area included 288 acres. As I mentioned, the initial NOI was extensively reviewed by the division and Geneva, and consistent with the division's rules, the NOI included explanations about the type of operations to be conducted, transportation and access, dust control and air quality, processing operations, stockpiling of materials, the type of equipment to be used, utilities, water supply and wastewater, existing soils and plants, plan for protecting the soils and plants, operation practices, public health, safety, and welfare, slope stability and erosion control, avoidance of hazardous materials, reclamation and stabilization, hole plugging, impacts to mitigation to water resources and impacts and mitigation to wildlife and cultural resources, revegetation and provided surety calculations. The division found that all those items had been properly addressed and issued its approval. In 2017, you'll see that an updated NOI was submitted. And the Phase 1 active mining operation area was increased to 335 acres. And the bond was appropriately escalated and posted by Geneva. Please note that in this 2017 revision, the permit area boundary still encompassed the entire 486 acres, but Geneva agreed to limit its active mining operations to the 335 acres. Other minor changes have been made throughout the history of the mine related to the boundaries and the operations. But recently in 2022, Geneva submitted and the division approved a release for the majority, all but 5.5 acres, of the west side of the freeway permit area. The bond area was appropriately reclaimed, the bond was released, and the NOI was updated accordingly. And the subject of the hearing today is the corresponding revision that Geneva submitted with or immediately following that bond release. And so this map that I'm showing here shows the 5.5 acres there on the west side. It covers a small pond area and a little neck to the south and the west of that. And then modifies Phase 1 to include the area within the original permit area boundary. And this modification results in a net increase of only 4 acres. So essentially what Geneva has done in this 2022 revision is swap disturbance on the west side of the freeway for disturbance on the east side of the freeway. As with the 2009 and 2017 reviews, the 2022 review included a comprehensive review by the division and by Geneva. Geneva's current revised notice of intention explains, among other things, Geneva's plans to implement safe and responsible operations pursuant to its operations plan, protect and redeposit existing soils, protect groundwater, preserve slope stability, control stormwater runoff and erosion, comply with air quality standards, address wildlife and plant habitat and endangered species. And after some back and forth with the division, as is customary when submitting a modification to a notice of intention, the division asked for some updates and asked Geneva to look again at a few things. And through several weeks of that process, the division finally issued its tentative approval. And notwithstanding that review, after the tentative approval was issued, several comments came in from Draper City and from the public. Those comments addressed various topics, including air quality, blasting and stability, property values, and other matters. And Geneva will provide a response here to those comments briefly. Our brief covers these in full detail, but I did want to touch on these items just here in a cursory fashion. So first, air quality. Geneva holds an approved approval order through the Division of Air Quality, which is the jurisdiction, or the state agency that has jurisdiction over air quality matters in the state of Utah. It's attached as Appendix G to the Notice of Intention. The approval order from the Division of Air Quality allows for the operations as they're being proposed and does not, importantly, contemplate an increase in production volumes. That makes sense because, as I explained earlier, the net increase to the acreage disturbance is a mere 4 acres, and the approval order it operates on equipment and production volumes and is necessarily limiting Geneva's operations according to those emissions related to the equipment that is identified in that approval order. Now, Geneva appreciates the significance of air quality matters in the Salt Lake Valley, most assuredly, and remains committed to complying with the standards that the Division of Air Quality has set. With respect to blasting and stability, I think it's important to note that the last time blasting occurred on this site was in 2012. If blasting is necessary in the future, Geneva will use professional trained companies, will be conscientious of neighbors as they have been in the past. The record shows that they have reached out to neighbors in the past on this very issue. In fact, the studies that were performed when that monitoring occurred showed that very minimal vibrations had migrated outside of the property. And so Geneva will continue to monitor those types of activities, blasting. They'll monitor slope stability. And I will note that there was a slope stability study that was contracted for during this process by Geneva. And the slope stability study, which is included in the NOI as Appendix H, it concluded that the area that was studied actually exceeded the minimum safety factors for slope stability. And so Geneva is confident that those matters have been adequately addressed. There was a concern raised with respect to property values and the development of surrounding sites and the effect that this mining operation might have on the surrounding area. We would note that property values have not been affected, in fact have increased around the mine, and development projects such as the redevelopment of the old prison site continue to move forward as planned. In fact, this project is likely very beneficial to those types of projects, since the construction products that are needed can be provided in close proximity to those development projects. So this is we see it as a benefit. It's actually a benefit to the community to provide these products in close proximity. But again, Geneva is aware of its neighbors and knows that they are there, and will be aware of them and be conscientious and try to be a good neighbor. Along those lines, another concern that was raised was this concern regarding truck traffic and rock chips. Geneva is certainly aware of the possibility of those types of impacts, and that's why Geneva implements training and safety programs. There's a state code that monitors load and covering load, height requirements, and so forth. Beyond those requirements, Geneva asks all of its employees, as well as the third parties that come and enter the pit, to remove debris off of their trucks. And there are tools implemented on the site to help folks do that. And so they leave the property in a way that's not going to cause damage. Clearly, Geneva is not the only party that uses roads in this vicinity. There are several other similar type operations nearby, and other construction projects, as well as weather and other things that can impact those types of things, natural debris on the road. But Geneva is conscientious of that and makes a sustained effort on a daily basis to mitigate those impacts. In addition, emissions are an important consideration with respect to these trucks that are driving around the Salt Lake Valley. And Geneva has gone to extensive lengths to track their truck traffic, optimize the routes that those trucks are taking. In fact, they've even looked at alternative propulsion technologies such as natural gas and electric vehicles, and have implemented all of those things to try to be a conscientious and good citizen in this valley. A concern was raised with respect to the flight parks. There's a flight park on the north and on the south of this site. And Geneva has actually worked very well with these flight parks in the past. On the south, there's an access road into the property that Geneva has maintained, has provided other maintenance for the park, and has been a great neighbor there. On the north end, you'll see that if you look on this map, the blue line actually covers a mountain called Steep Mountain, and they own the property that covers the north face of Steep Mountain. Not entirely, but a large portion of that. They have intentionally drawn the boundary for the disturbance area in the red area so as not to encroach on the face of Steep Mountain. And they're conscientious of that use, and they want to be a good neighbor, and so they've taken those steps to mitigate those concerns. We're aware of no evidence or proof that these operations will impact wind patterns or negatively impact the sport, and we would submit that any statements to the contrary are at best speculation. We just don't have evidence of any damage to the wind patterns. With respect to the concerns that were raised about wildfires and flooding and other safety matters, we want to note that Geneva is actively monitoring for such events. If any of those events occur, they have plans in place and training that they give to employees as to what to do in the event that something of that nature were to occur. Geneva values safety. They clearly do not want any of those types of things to occur, and the plans that they have on site, we believe, protect against those types of accidents. There were some concerns regarding water usage and impacts to water. And Geneva knows we're operating in an arid state. We're in an ongoing drought. And that's why Geneva recycles water on the site. They've spent significant capital in monitoring water and using water in a conscientious manner. Most of the water on this site comes from groundwater sources, which is pumped, which costs to pump, and so it's in Geneva's interest not to pump more than is necessary. They have a more efficient and cost-effective operation if they don't excessively pump, and so they are aware of that, and they're necessarily limited. There was a hydrology study that's attached as Appendix I to the NOI, and it identified potential effects on the subject aquifer and the Jordan River ecosystem, and concluded that Geneva's operations would not materially impair those resources. There was a concern regarding the recency of the information that Geneva has submitted with this NOI. And I would just note that with this NOI, Geneva submitted a stormwater pollution prevention plan that was dated in February 2022, an air quality approval order that was dated in July 2021, a slope stability analysis that was dated February 2022, and a hydrology study that was dated in February 2021. These are very recent results, very recent information. There was a concern regarding the recency of the wildlife or plant study, and the division has indicated that it conducted its own independent recent analysis during this review process in 2022 and concluded that there was no critical habitat here. It's consistent with the original conclusion in 2009, and there have been no significant changes with respect to those matters. Finally, there were some concerns expressed regarding the reclamation at the site. I would just like to note that the general overarching purpose of the Utah Mined Land Reclamation Act, found in Title 40 of the Utah Code, the purpose of that act expressly states that it is to facilitate mining operations. It's not meant to find ways to prohibit mining operations or stop mining operations. One of the ways that the Act does this is it requires operators to submit for large mine operations a reclamation plan and a reclamation surety to ensure that the operator fulfills its commitments to reclaim the property at the end of mining. Geneva has done both of those things. It has submitted a robust reclamation plan that calls for reclaiming the property at the conclusion of operations and has guaranteed those commitments with a sufficient reclamation surety, over $3 million, which is in place with the division already, and it has been posted. At the end of this mining operation, soils will be redeposited and revegetation will occur in the areas identified in the plan, and this will provide for an adequate post-mining land use. And so the purposes of the Act have been fulfilled in our view. So in conclusion, Director Baza, we really do appreciate DOGM's careful review. We appreciate the comments that have been submitted and the opportunity that we've had to look through the NOI and double check and relook and bring ourselves to a level of comfort that we are pleased that the division has given its approval. We think that's the right conclusion. We agree with DOGM that all the critical parts of the revision have been addressed and there are no deficiencies. So we respectfully request that the division issue final approval of this revision. Thank you. Oh, and if there's time remaining, we would like to reserve that at the end for rebuttal. Thank you.
Thank you, Mr. Wallen. I have like 2 or 3 questions I'd like to ask, just clarifying questions. You talked about truck traffic, and I can truly appreciate that Geneva has a big stake in this, safety and things like that. Are there UDOT requirements on, say, debris falling out of trucks or maximum speed or anything like that?
I personally am not aware of UDOT requirements. We'd be happy to check with the client and report back on that.
Yeah, there are, like, you have to, like, cover your load and keep the rocks off the trailers and stuff.
Yeah, we're aware of the state code that provides for load covering requirements and things of that nature. And I'm not sure if they come from UDOT or they come from the more general state code, or if they're in the title that governs UDOT, or where they fall.
Yeah, I'm not trying to get into the specifics of it, but I'm just wondering, is there another agency who's kind of overseeing that compliance with state code?
Yes, I believe, now, again, this is personal knowledge. I don't know if this is, we can confirm this, but my understanding is that the jurisdiction to carry out that state code provision does not fall with the Division of Oil, Gas, and Mining, and it falls with other state agencies.
Okay. Another question is along the same lines. You mentioned the flight park and how you have avoided encroachment onto Steep Mountain. Is there another state agency that oversees that interaction of activity?
Yeah, that property on the north side, on Steep Mountain, the flight park there is owned by the county, Salt Lake County. And so I believe they have the jurisdiction and so forth to monitor their property that they own there. On the south end of the property, the flight park to the south is owned by the state Division of Parks, I believe. It's a state facility. And again, outside of the jurisdiction of the Division of Oil, Gas, and Mining.
Lastly, on my questions, you talked about site reclamation and ultimately what the reclamation plan will be. Do you have an idea at this point, or your client, about what is the life of the mine?
Many years. Decades, they'll be operating out this site into the future. We don't have a specific number of years, but it will be a number of years into the future that operations will occur. This is a prime geologic spot. These materials don't occur in every single location. You can't just pick a random mountain and go and extract these materials from anywhere. And so due to the geologic nature of this, they would like to maximize the potential there and mine until that resource has been fully utilized. And we think that's in the public's interest because these products provide critical public infrastructure and resources for construction, and providing those in an economic way is a benefit to the community.
And you mentioned your financial assurance, the surety bond that you have in place. I may have some questions for the division about that, but we'll hear their presentation later.
Great.
Thank you.
Thank you.
Well, with that being concluded, we will return to Geneva later on. But at this time, maybe we could have the counsel with Draper walk us through your statements.
Yes, thank you. And thank you for the opportunity. Draper appreciates the opportunity to appear and express its concerns and why it believes that this version of the RNOI should be disproved by the division. Geneva is requesting that the division grant approval of a 61.5 acre expansion of its current bedrock mining operations into an area that's zoned for agricultural and open space. It wants you to do that now without proof that it has zoning approval or change of zoning or even a vested mining use, which is an issue that is currently under litigation in the state courts. It also wants the division to provide that approval now before it has provided a rigorous review of the impacts of its expansion or updated its permits that are almost 15 years old. The division wrongly believes that it must approve the plans as they've been submitted by Geneva now without waiting to see whether or not Geneva has land use authorization to expand into this area. We believe that the division is wrong on that issue. The division does have authorization to deny a request for approval that is speculative. And in this case, Geneva's application is speculative because it doesn't have land use approval or a ruling from the court on its argument that it has an exclusion from Draper's zoning. The division also has authority to require a more rigorous analysis from Geneva. And on that point, I want to point out that the information that we heard today from Counsel for Geneva is much more, has much more factual analysis than the request for the notice of intent to mine that it actually submitted. Why is that information not in the notice of intent to mine? For example, Geneva mentioned multiple things that it's potentially doing to mitigate traffic impacts, wind issues, dust, but it did not include that information in the notice of intent to mine that is actually subject to potential enforcement by the division. So Draper's position on this subject is that Draper is not seeking to block or stop lawful mining. Draper does recognize that these materials have some value and public use. What Draper seeks to get from the division is an acknowledgement that Geneva first needs to get the land use approval and to do a sufficient analysis of all of the impacts, and particularly in this context where there is so much public interest and concern and observation of past harms under the existing permits. So in the remainder of my presentation, I'm going to go through 3 issues. First, the harm to Draper's interest in this case. Second, I will discuss the division's authority to disprove the RNOI. And third, I will discuss in further detail why this application is speculative and incomplete at this time and must be disapproved. So first, as I mentioned, Draper is seeking to enforce the existing land use limitations in this area. It wants Geneva to go through the appropriate process of zoning and land use authorization approvals, through which process the issues that the citizens have raised, such as air quality, health, nuisance dust, nuisance vibration, traffic hazards, elimination of open space, and the agricultural buffer, visual impacts and impacts on the flight park can all be The division indicated in its brief on page 11 that it believed that Draper had not raised specific public safety and welfare concerns. To the contrary, the request for agency action on pages 3 through 5 has an extensive list of the comments that it considers of concern. And in addition, prior to my presentation, I passed out a folder that contains exhibits. In that folder are additional declarations from citizens in Draper, some of which, all of whom had previously provided comments, some of which are on the list of substantive commenters that the division determined it would consider, as well as a copy of the Utah Physicians for Healthy Environments comments on air quality and potential impacts on health of the mine. Those comments are provided because they go to Draper's interest and establish that Draper, as the regulatory body that regulates local land use in the area, has a sufficient concern in health, safety, and welfare, and zoning, and also in elimination of public nuisances to participate in this proceeding. So, turning to the division's authority, the Utah Supreme Court has described the division's authority under the Utah Mined Land Reclamation Act as follows. It says, the Utah Mined Land Reclamation Act requires affected mining operations within the state to ensure that their lands are restored during or after mining to a safe, stable, ecological condition and use, which will be consistent with local environmental conditions. To implement this objective of reclamation, the Mining Act charges the board with enacting rules necessary to carry out the purposes of the statute. The statute further authorizes the board to take such other actions within the purposes of this act as may be necessary to enforce its provisions. The citation for that is Associated General Contractors versus the Board of Oil, Gas, and Mining, 38 P. 3rd, 291, 2001, and it cites 40-8-4 and Utah Code 40-8-6. Additionally, the Act's legislative findings acknowledge that it's necessary to extract minerals required for society, but finds it desirable to, quote, minimize undesirable effects on surroundings. That's in 40-8-2, subsection 2. The legislative findings also say that the act is intended to prevent conditions detrimental to the general safety and welfare of the citizens of the state and to provide for the subsequent use of the lands affected. The objectives of the act, which are in 40-8-12, include minimizing and preventing on-site and off-site environmental degradation, both during and after the mining operations have concluded. The division has authorization to impose and enforce conditions for the health or safety of the public and or for significant harm, to prevent significant harm to land, air, or water resources. That's in 40-8-9. Both the division and Geneva, in their briefing, have relied on a couple of subsections or sections of the statute where the division is directed, or the Board of Oil, Gas, and Mining is directed not to abrogate or interfere with the Department of Environmental Quality, and also a clause that the operator is not relieved by grant of a permit from complying with other applicable regulations. Those two provisions do not remove, are intended to remove duplicative requirements, but they do not deny the division the authority and the responsibility to consider impacts to the health of the environment and the safety of neighboring residents, both from ongoing mining operations and also in the reclamation of the mining after it is complete. And as Director Baza asked as to the issue of how long this mining is going to occur, Geneva responded that there is not a specific end date, and it may continue for the foreseeable future. In that case, it is particularly important that the health and safety of the residents in Draper be considered by the division while the mine continues to operate. So, despite the division's arguments about limitations on its jurisdiction and whether other agencies have a role, we submit that that does not prevent the division from taking appropriate measures to consider the site-specific impacts of the mine and impose conditions and mitigation measures that require those things to be minimized. So turning to why the division should deny this specific request for notice of, well, the revised notice of intent to mine. First of all, as I indicated before, it's speculative. There is no zoning approval or a court ruling on the vested mining use. Currently, the area that the Geneva intends to expand into is zoned A5 for agricultural open space. And the prior land use decision that Geneva has cited in its brief concerns sand and gravel extraction, not mining, and does not provide it authority to expand into this area. Accordingly, until Geneva has a land use authorization in the form of a zoning change or a decision of the court, its request for intent, its notice of intent to mine is speculative and is subject to change in a zoning process and should be considered by the division after that process is complete. Second, as indicated before, the notice of intent to mine is incomplete. Regulation 647-4-118.1 requires all information concerning a revision required for the initial notice. Much of the information that was provided by Geneva in its oral argument here was not included in the request, in the revised notice of intent to mine. It has not analyzed the impacts of expanded disturbance on dust. It has not included production limits in the revised notice of intent to mine. In fact, it removed those limits, and those limits are now only contained in the air quality approval order from 2009 that was only updated in 2023 to add a single generator. They removed the production limits from the language of the revised notice of intent itself, and presumably would argue, based on their position in this case, that they could, in the future, change those production limits with the Division of Air Quality without impacting the notice of intent to mine, which is relying on those production limits, not only for air quality impacts, but also for dust and other issues. Additionally, it has not considered traffic and has not conducted a complete impact analysis. For example, regarding the Endangered Species Act analysis that's required by the regulations, that endangered species analysis requires a updated consideration of critical habitat, but also of the species list as it is currently constituted, which it has changed since 2009. In conclusion, Draper requests that this division disapprove the current RNOI and require Geneva to resubmit it when there is a permit request that is not speculative and in a complete form that at the very least contains all of the representations about production limits and mitigation measures and studies of harms that Geneva has described in its oral argument today. Draper requests that the division require Geneva to put the horse in front of the cart rather than the cart in front of the horse. Thank you.
Thank you, Ms. Whitnam. I have a couple of questions for you as well. You mentioned zoning. Is there current consideration being made towards any zoning change, or is that a process that has yet to be started or considered?
My understanding is that there was previously an application for a zoning change submitted by Geneva, but that Geneva has put that on the back burner while it is litigating with Draper City about whether it can ignore Draper City's zoning ordinances because it has a vested mining use, or because its position is that it has a vested mining use.
Can you, maybe in summary, tell me what the status of that litigation is?
Yes, and in fact, I included a copy of the answer in the exhibits that I handed to you.
Okay.
So Geneva has answered Draper's complaint, and the parties are in the discovery process right now.
Thank you. Regarding zoning again, are you aware, has local government been blocked or stayed or prevented from exercising its land use authority at this point?
No.
Okay. Is there a decision that needs to be made by local government in that regard?
No, there's not a pending action that would give Draper enforcement authority. Draper has taken the action it can at this point in time, which is to seek declaratory relief from the court based on Geneva's expression of its intent in this proceeding and also in the answer that we submitted to continue or to proceed with mining without Draper zoning approval.
Okay. Well, thank you for that. I really wanted to know what the follow-up actions outside of this division would be. All right. It's time to turn the podium over to the division for your no? Oh, objectors. Okay. Sorry. That's why I have counsel. So now we've only got 3 individuals who provided written objections of substance and reserved a spot today. They are Jason Rickabaugh, Ferris Taylor, and Robert McFarland. If those individuals are here, would you please come up in that order and you can discuss your comments through the microphone there. And make sure you press the button and get the green light.
Thank you, Director Baza, and for holding this meeting today and for everybody for being here. I appreciate Geneva's counsel's comments on the preamble of the Mine Land Reclamation Act. One thing to keep clear that I'd like to point out or emphasize is that it's part of the division's mandate to mitigate some of the bad effects, the negative effects of using the land to further society. But what happens when it's impossible to mitigate those adverse effects? Utah has recently hit a benchmark of 3 million residents, and 2/3 of those, I believe, live in the Utah and Salt Lake Valley. This operation is right in the middle of that in a very high spot. I was thinking last night about some people's ambitions to have skyscrapers in the valley, and it was just very interesting for me to think, like, we're going to have a very significant point source of pollution that will actually be above these skyscrapers. Also, Utah has a lot of vested interest in the new developments down at the point of the mountain for the prison property. And the legislature has taken a very hands-on approach for this, and it's very important to Utah's economy. I believe they're also going to put about, 40,000 new residents down there. And the pollution, or should I say fugitive dust, is well known to go down and migrate to that area where all these new residents are going to be. So I hope the division seriously considers that. Also in my research, which I believe I've made available in the past to the division many years ago, there are wind stations up there at the point of the mountain. And I went back historically, I looked at the 5 years it was available from the University of Utah, and found that about 2/3 of the wind observations every 5 minutes were over 20 miles per hour, which I believe is beyond the point where Geneva is required. I think they might have changed it recently to 25 miles per hour, is required to use dust mitigation measures. I'm also very concerned about the state's interpretation of what the legislature has done recently with Geneva's claims about the vested mining rights. Are we really to understand that the legislature intended to usurp the city's zoning authority, which is almost the primary purpose for the city is zoning and land use. I'd also like to point out that these lands that they're trying to expand their operation to are properties that are purchased well after the zoning authority was established. And this should be considered an expansion. There's also unresolved issues in adjacent operation in the Lehigh area, which brings material into the point of the mountain. And this operation and a lot of the stuff in general are very abnormal. It's my understanding that the one operation is inside of an HOA, and they're even trying to extend that to a part of the HOA, another part of the property, which is inside of an HOA, that has already had, which is a covenant side of it. So, this is some very irregular stuff, and I hope that the division can look at it in that manner and maybe take some irregular steps, because it's such a very important part, or the effects of this operation have a very deep impact on the residents of Utah. There was an article in KSL the other day where they were questioning, where does all the brown pollution come from, the smog that's hanging out over downtown. And just please remember that there's a predominant south wind, and that in the mornings, and that I believe that a big contributor to that is going to be Geneva. Likewise, I also believe that, and I don't know what the division can do about it, but I believe that this is unconstitutional according to the state's constitution, in that the legislature is attempting to establish a monopoly. They've picked an arbitrary date by which they say that these operations have some type of vested right to ignore local zoning authorities. And I believe that will be detrimental to other operators which deal with the division, and possibly new ones in the future, and that impact could have a negative economic impact in the future on the state and require the state to rely on only a few providers. And just remember, this is a very highly densely populated urban area. The operator is trying to make a major expansion of operation that type of operation that is known to have significant amounts of pollution. And I believe there's no question that, people can go to the point of the mountain every day and during the better weather seasons and see fugitive dust escaping the mine to the point where the Air Quality Division should do something about it, but apparently is unaware or unwilling to enforce this. I believe more time needs to be taken, and the division should ask the operator to deal with the city and to find a better resolution. Operations like this have a life cycle. They're usually put outside the cities grow up around them, and then the operations are not allowed to expand. That's typically how it works. Are we going to do something different than that? Are we going to allow the operator to ignore the local zoning laws? And, I'm not sure what the division can do about it. It has their ability to enforce the laws and rules. But, I just wanted to point out again that there's a lot of things that are not normal that are happening here, and I hope the division will take extraordinary steps to make sure that the health, safety, and welfare of the residents are protected from the adverse effects of this type of operation. And also, I'd like to reiterate what the city's council said about the NOI. It has a lot of deficiencies and some incorrect facts in there. I believe in 1999, the result of that, and I think 2005, was that Geneva had no, they basically agreed to reclaim the entire property. And I don't think that is clear in the NOI. And
Just to clarify, you're Mr. Rickaball, right?
correct.
Okay, you are well over time. I've provided
Okay, I appreciate
some
that, sir.
latitude, but I believe some of these same comments you're making were included during the public comment period, right?
Yes.
Okay. Well, thank you for your comment.
Thank you for your time.
We'll now turn to Mr. Taylor. And it would help if you introduced your name for the record.
Yeah, I don't believe Mr. Taylor's here, so I'm Robert McFarland.
Oh, okay.
And I'm a longtime resident of Draper. I lived there for about 20 years, and I moved away 3 years ago because of Geneva Rock, because of fugitive dust. When you think about the mine location, let's go back in time. 70 years ago, it's a pit at valley level. That's one thing. Now, Lehigh is one of the fastest growing cities in the country. That area around there has grown over 400% since 1990. The populations are right there. So when there was the division I lived, the subdivision I grew up in with my family was on Steep Mountain Drive, and that's right below this proposed mine. And it was approved in 1996. And when you look back, this isn't land that was owned by Geneva in one cohesive piece forever. They acquired this property in 1999, and I'll share the title information with you on that. And then in 2015, Geneva sought from Draper City a rezoning request. And when I bought my house, I bought it based on local law. I bought it based on government agencies taking care of the health and safety of my family. And when I looked there, that the land above the house was zoned A5. And what that permits is one house every 5 acres. It doesn't talk about industrial use. It doesn't talk about a mine above a 30-degree slope right above my house. So, when these battles are going on and I see that companies like Geneva are not trying to go through the local process, it's very troubling and it's problematic for me. And for them to say that there's no economic impact of having a mine, how many realtors will say, oh, it's got a lake view, or it's got a golf course view. How many realtors sell that there's a mine right outside the backyard and it's going to expand and it's going to grow for decades? And when Geneva talks about impacts, they're like, there's not going to be any net increase. But if this mine goes for 70 years, it means there'll be diesel trucks rolling down Silicon Slopes for 70 years. It means that the Division of Air Quality will go up there once every 18 months and measure opacity, on whatever day it might be. If that is the standard, that's insufficient to provide the health and safety of residents who live near the mine. And so I think there are a lot of things that if everything was functioning perfectly, then you could trust these other agencies to take care of it. But the actual reality of it, and living there and seeing the air quality impacts, it's not working well. They're doing what they can. They're using 1.7 billion gallons of water a year. That's enough to take care of 19,000 households. So if they expand another 50 acres, several hundred feet higher on a ridge line, you've all been in the mountains. Where's the windiest part on a mountain? It's right on the ridge line. And as they moved up in Lehigh, we would see dust billow over, and it would come into Draper. Right in that Venturi between the valleys, 80% of the days there's winds over 10 miles per hour. That's enough to stir up the dust. It is a terrible location. I mean, certainly for a $5 billion a year revenue company, the margins are good when you can just roll it down the hill and send it to your customers right in the backyard. There's no question about that. But what are the ethics of subjecting the populations that are right in that area to these health hazards? These are known carcinogens. That's what I learned about. I didn't know that when I just saw a gravel pit. Oh, it's just a gravel pit. No, this is silica. My brothers are doctors. My brother's on UPHE, and he has plenty of data that talks about it. And I would recommend that you read that information. There are thousands of health studies that show the negative impacts of this on the entire population. And when you hear people talk about worrying about the Great Salt Lake drying up, and the problem there is dust, fugitive dust. Owens Lake, California, fugitive dust. This is worse than that. This is in a Venturi between valleys, and it starts hundreds of feet above the valley floor. So this will hit Salt Lake and Utah County and even into Davis County. And, we have a friend here who has purple air, and one of the reasons they started these monitors was to kind of get a handle on what happens when the wind picks up. And when you see the wind coming from the south, you can look at purple air monitors in Bluffdale and all along the valley, and you will see spikes. You will see increases in the pollution levels. So I think you need to take a step back. There's no rush here. Geneva has tried to get this through Draper City, going through the front door. It now seems like they're trying to go through the back door. And I would say don't facilitate that. Make sure that the proper due diligence is done and that there's a different standard. This isn't 70 years ago. This isn't an innocuous mine on the valley floor. This is in the heart of our most powerful economic engine in the Silicon Slopes. And people are at-will workers. They're going to choose to live where the quality of life is good. And if it's not there, they're going to choose to move. And so it's a trade-off that the state is making in terms of are we a mining place or are we clean tech? And if you open up a mine and another 50 acres at high elevation, you're saying we're about mining and industrialization.
Again, Mr. McFarland, you're
and not
well
about
over time,
health.
but I appreciate your comments, and I think you're reiterating, again, some of the same things that were included in your public comment. So thank you for that.
Thanks.
So let me make sure that Mr. Taylor is not in the room and will not be commenting today. Okay, with that, now I believe it's time to turn the time over to the division.
Thank you, Director Barza. I lost my system. Perfect. Thank you for the opportunity to address this issue and to talk a little bit more about the permitting process and what the division's review of this permit application looked like. A little bit of background on this project. Sand and gravel operations have been conducted on site since approximately the 1950s. As Mr. Wallen indicated, in approximately 2004-2005 time period, the division determined that those operations, which previously were not regulated because sand and gravel unconsolidated material is not regulated by the Division of Oil, Gas, and Mining. But in 2005, they determined that the mining operations had begun mining into the bedrock and that Geneva would need to obtain a mining permit from the division. They applied for that permit in 2005. It underwent a very extensive technical review over several years. The permit was ultimately approved in 2009. And so it was a several-year process to review and approve that permit. I'd like to show again this map that came in with the original NOI approval. And this red boundary is the boundary of the permit area. So mining has been approved already in 2009 everywhere within that red area. So the proposed expansion or the new area of disturbance is actually found in that upper right corner and has already been permitted for mining. What the NOI contemplated in 2009 that was approved was that although the entire permit area of 486 acres was approved for mining, only approximately 280 acres in the Phase 1 boundary area had been designed for active mining and reclamation, and that was the only area that Geneva had provided a bond for. So they committed to keep their mining operations within that boundary. The NOI specifically stated that any further phases of mining operations, once they were designed, would need to come back to the division for review and approval of the reclamation and to ensure that there was appropriate surety in place. I'd like to show you, it's kind of hard to tell from some of these just diagrams, if you could go to the next, what we're looking at here. This is a 3D map of the general area. The north is to the left of that picture. The shaded area is what is currently being mined by Geneva. That is the Phase 1 operations currently in existence. Geneva, with its revision to the NOI, is requesting to disturb, if you can go to the next, thank you, the area that is shaded purple. They're asking to disturb that area within the permit. And it is an approximately 76, 77 acre area up along that ridge line. The ridge that you see on the left of the shaded area, that is the steep mountain that was referenced, that the flight park, there's some flight park recreation area to the left of Steep Mountain, and then there's also some flight park recreation to the south of this area. One important thing I think to recognize is this is the Geneva Point of the Mountain permit. There are 2 additional sand and gravel mining operations right in the same general vicinity. Because they are sand and gravel, they are not regulated by the division. There is, I might get these mixed up, I believe there's a Staker Parson sand and gravel permit directly to the south of Geneva, and then there is a Kilgore pit that is on the west side of the freeway and south of Geneva's operations on the west side. So when the division, again, originally approved this permit in 2009, it was contemplated that mining operations would at some point extend into this new undisturbed area, and that has already been approved. The division, since that has been approved, has very limited options as to what it can do. The statute is very clear as to the fact that the division is not allowed to withdraw approval of a permit. It is, except for in certain circumstances. And if you'll pull up 40-8-16. This is the statute that talks about when the division or the board can withdraw approval of a permit. And it can only be withdrawn under subsection A if the operator substantially fails to perform reclamation or conduct mining operations so that reclamation can take place. B, it can be withdrawn if the operator fails to provide and maintain surety. And under subsection C, it can be withdrawn in the event that mining operations are continuously shut down for a period in excess of 5 years. We don't have any of those situations in this case. So the division cannot withdraw approval at this time from the permit area that has already been approved. What the division, and so I do think that's an important distinction to make. I think there is a perception that the division's review process was to determine whether or not mining in this area was a good idea or whether it should go forward, and that is not the case. The division's review is limited to whether or not the proposed reclamation plan that was submitted and whether the proposed surety calculations are accurate and will provide for adequate reclamation of the newly disturbed area of the permit. So, with that, if you look to the Mined Land Reclamation Act, that is the statute that gives the division authority to regulate mining. 40-8-3 specifically states that the purpose of the act is to provide that all mining in the state shall include plans for reclamation of the land affected. The division conducts its review with the end of the mine as its goal. What will this look like when things are done with the mining, and making sure that there is an appropriate post-mining land use, that there is not environmental hazards left behind, that it is in a safe and stable environmental and ecological condition. And so with the revision, the revision that was presented to the division in 2022, it was a request to provide a reclamation plan for this newly disturbed area and to provide new bond numbers based on the 2022 bond calculations and this newly disturbed area. So when the division looks at this revision, the rules that the division operates under establish that although you have to include in the NOI everything that would be required in an original NOI, for the revision, you're only going to review what is being revised. And so the division based its review for that newly disturbed area and conducted the review that is dictated by the rules. And those rules are found in Utah Administrative Code, Rule 647-4-103. And it's actually 103 through 112. And those rules dictate what must be included in a notice of intention in order to be approved by the division. And those rules deal with information relating to the operator, surface and mineral owners, maps, drawing, and photographs that must be included in the NOI, an operation plan, hole plugging requirements, an impact assessment, reclamation plan, and if there are any variances requested from the rules, what those would look like. When the division conducted its review of this permit, it looked at every single one of those rules to ensure that the proposed plan met the requirements. And they ultimately determined that there were some deficiencies in the original submittal. And there was some back and forth with Geneva. There was significant conversation about topsoil reclamation. There is a lot of potential topsoil there, how that topsoil was going to be stored, how it was going to be protected against erosion. There was information relating to the hydrology and potential effects on the aquifer. The aquifer there. They requested modifications to the revegetation standards. Perhaps the most significant was some requested revisions to the high wall slope, the end high wall slopes, that they felt, given what has been seen from the geology of that area, the high walls do tend to erode and flake, and that there needed to be a much less steep slope to make sure that that could be maintained safely long-term. Geneva and the division worked through these issues, and the final RNOI that was tentatively approved by the division includes the modifications to address the division's concerns there. The Draper City and the public objectors have raised some very valid points about dust. Dust is an issue in that area. As part of the division's review, they were in contact with the Division of Air Quality, and they verified that Geneva was in compliance with its current permit, that there were no recent violations, that there was dust mitigation plans in place and currently approved by the Division of Air Quality. The Division of Air Quality approval order was attached as part of the NROI, and that, or the RNOI, excuse me. And that actually is part of the approved RNOI, is the approval order. The dust mitigation plan that is included in that becomes part of the reclamation and operation plan. So although there was some language deleted from the narrative description, those requirements are still in place. They are still required as part of the appendixes. There were also significant scientific studies that Geneva included as part of their RNOI. There was a hydrology study that was conducted in 2022 that specifically looked at the effect that the proposed operations would have on the aquifer and the Jordan River ecological system. That hydrological study determined that there was going to be very minimal effect. There was a slope stability study that was submitted to make sure that the proposed operations and slopes, as mining operations continued, would be safe and that they would be left in a stable condition. And that study found that actually the proposed operations did exceed minimum safety requirements. Again, the air quality order that was provided as part of the application was recent, from 2021. It included all of the equipment that was utilized on site, and it included the dust mitigation plan. And an important thing to note about the air quality approval order is that those orders are not based on geographical location. They're not tied to a specific spot. They're based on operations. And so because there is a production limit imposed in that air quality approval order, it doesn't matter where this disturbance has taken place. They can't exceed those production limits without having to go back and get a new order. So another way of saying that is, from an air quality perspective, there is not going to be an expansion of operations. Expansion implies increase, and from an air quality perspective, they have already been approved to do a certain amount of production, and that is still all they are allowed to do, regardless of where that production takes place. When the division reviews these applications, we do seek public comment because we are concerned with making sure that safety and health are adequately protected and that we are doing everything we can to make sure that mining can coexist with the surrounding population. It's difficult. While the division can impose conditions to help mitigate some of those undesirable effects, it's difficult to do so when we don't have an idea of precisely what people would recommend. Although, the dust is an issue, as the division reviewed the submittal and discussed with the Division of Air Quality, there is a dust mitigation plan in place. They are in compliance with that order. There hasn't been suggestions that the division could consider as to what additional steps could be taken. With the hydrology, similarly, while there is a concern that there could be negative effects, when the division reviews the plan, it appears that there is not going to be any negative effects identified, and there haven't been any proposed mitigation efforts that anyone has said that they would like to see implemented that the division can consider to see whether or not that would be appropriate. At the end of the day, the division is an administrative agency, and we are only granted the authority that our statute grants us. We can't act independently of any authority that is given to us by the statute. And the other agencies in the state of Utah are similarly granted authority. And the Division of Air Quality and the Division of Water Quality are the main agencies tasked with ensuring that those issues are appropriately dealt with by mining operations and any other type of business. And while we can attempt to mitigate, we have to also respect the bounds of our authority, and air quality is not what we regulate. And on that same issue, there has been some discussion about the vested mining use and whether or not Draper City has the ability to zone in such a way that mining is not allowed, or whether Geneva can expand into an area that is not zoned for mining. And I think that is a very important issue, but it is also one entirely outside of the division's control. The division has not been given the authority to regulate the vested mining use statute. That lies with the courts, and that is where litigation currently is ongoing to determine whether or not Draper and Geneva, what the end result will be. The division statutes make very clear under 40-8-17, if you want to pull that up, that the approval of a permit by the division does not relieve the operator from responsibility to comply with all other applicable statutes, rules, regulations, and ordinances. They must continue to comply with air quality. They must continue to comply with water quality. And they have to figure out the zoning and the ability to mine in that area if they wish to do so. Our permit is just to ensure that the reclamation plan will provide for a post-mining use that is suitable for the area and the geological environmental conditions, and to ensure that in case something happens and Geneva does not perform appropriate reclamation, that the state has the surety in place that it can come in and take care of cleaning up that area when mining operations cease. On the bonding issue, the division did do updated bond calculations as part of its review and came to a number that was approximately $2.2 million would be needed to appropriately bond for this area. Draper currently has approximately $3.1 million in bonds that the division is holding. The area to the west of the freeway that Mr. Wallen referenced, when that was reclaimed and the bond released from that specific location, Geneva asked the division to hold on to that bond. So we currently are over bonded for this project by approximately $900,000.
Let me ask a clarifying question there.
Yes.
I think you said that Draper holds the bond?
I'm sorry, not Draper. Excuse me, the division holds the bond
On behalf of Geneva.
on behalf of Geneva, yes,
thank
to ensure that reclamation takes place. And the only other question I would ask of Draper and the public is if there is a feeling that additional analysis needs to be done to assess impacts. I would ask what analysis they anticipate that needs to be. The hydrology was studied, the slope stability, the post-mining slope stability was studied, air quality has reviewed and approved the dust mitigation control issues, and we are happy and very willing to consider any and all concerns, but we need some direction as to what additional analysis they think is necessary, because from the division's review, we believe that this application did satisfy the statutory and regulatory requirements. And unless you have any other questions, I'm done.
Yes, I have a few questions. Let me go back to the bond, the financial assurance. You indicated that the bond has been revised over the years as revisions to the original NOI have been considered. On a standard basis, let's say no revision to the NOI was being asked for, would the bond ever be recalculated and how often?
So bonding is escalated every 5 years to ensure that the amount the division is holding is adequate to reclaim. I believe it was escalated during the 2018 amendment or revision that approved deepening the pit. And so it's currently escalated to 2022, and that will continue to happen every 5 years.
So if we assume, as Geneva's indicated, that the life of this mine is many, many years, then we would also assume that every 5 years we'll be recalculating the financial assurance.
Yes.
Okay.
And I believe in the NOI, it says that the proposed life of the mine is tentatively 75 years.
Okay. You showed a 3D map and as part of your presentation. Is that part of the NOI or is that an internal document?
That is that's an internal document because I am not a scientist and I wanted to see what it was that we were talking about.
Okay. And I don't know if that map shows it, but does the mine cross government jurisdictions like city boundaries or county boundaries?
Will you pull up? Why don't you show me the 3D one? Yep. Okay. If you can see on this picture, there is a kind of a white dotted line that goes straight up the middle.
I can't really see it. But
Okay.
that's my eyeballs. So
And I'm going to ask that the division poke me if I'm explaining this wrong. My understanding is that basically is the geographic boundary of
see your
the
cursor.
Salt Lake County and Utah County. And to the south or to the right, that is the Utah County permit. And frankly, that is one of the concerns with not approving this this NOI is that the permit to the south that has Utah County zoning has already been approved to take down that mountain. And if something does not happen on the north side of that county line, you're going to be left with very steep cliffs. That will be a potential problem for erosion and safety. And this is a much safer option to deal with the entire area versus splitting it right along that ridge.
And you're saying that from the point of view of the division and public safety, not
Yes.
the mining operators.
No, yes, from the division's view, it would be much better not to have very steep high walls left behind as a result of these mining operations.
Understood. So you indicated as part of your presentation that the rules don't allow the division to withdraw approval of an NOI. But maybe I'm just asking this to put it on the record. There is continual enforcement of the requirements of the rules, right?
Yes, and the statutory provision that I cited to, those are how the division can withdraw an NOI generally outside of enforcement. There is also the ability, if there were violations of the permit or violations of the statutes and rules, we have the ability to stop mining operations to address those violations. Currently, there are no violations associated with this permit.
And that those violations could include failure to comply with a condition of the approval.
Yes.
Okay. You talked about the rule saying how you were to conduct a review of NOIs, and you made a comment, and maybe you can clarify for me. I think you said we have to do an impact assessment. Are there specific criteria or standards regarding an impact assessment?
Yes, so that specific rule is Rule 647-4-109. And that rule provides that as part of the NOI, the operator shall provide a general narrative description identifying potential surface and/or subsurface impacts, and that the description will include, at a minimum, potential impacts to surface and groundwater systems, potential impacts to state and federal threatened and endangered species or their critical habitats, projected impacts of the mining operation on existing soil resources, projected impacts of mining operations on slope stability, erosion control, air quality, and public health and safety, and actions which are proposed to mitigate any of the above referenced impacts.
That's what I wanted to clarify, that there are specific statements about what we are supposed to analyze in that regard.
Yes.
Okay. Another question is, you mentioned several other mining operations occurring in the immediate vicinity of this mine. Is there anything in statute or rule that requires a cumulative assessment of the impacts of all of those mining operations together?
I am not aware of any requirement to perform that analysis. That would be particularly difficult since the division can't even regulate the other two operations. They are exempt from our statute. And so if we were to do cumulative impact analysis, I think there would be an issue that you would be penalizing the operation that was subject to our requirements, since the other two could continue operating without any oversight by the division.
And is that the reason they're not oversighted by the division? Is that a size component or something to do with the nature of the deposit?
I'm not entirely certain. My client is telling me it is a size component. Typically, if it's unconsolidated material, rock aggregate material, it is not regulated. It might also be that it is a certain size.
The size of the mine. Okay. Last question for you. Does OGM's approval require other governmental approvals to take place?
It requires other approvals to the extent that the issuance of a permit does not allow Geneva to go out and begin mining immediately. If the division were to determine that Geneva was mining without the necessary approvals, I think there might be the ability to take enforcement actions based on that, that they were mining without appropriate approvals. However, from the division's perspective, the issuance of the permit is usually the first step in the process. Many of the other agencies and cities and counties require a permit in order to process additional permits that are necessary. Draper did raise a point that at the current stage, the application is speculative because there's no guarantee that they will be able to move into that area based under current zoning laws. And that may or may not be the case. From the division's perspective, our statute requires us to analyze and review a submittal within a certain time period and to issue a decision. The statute doesn't grant us the ability to put it on hold because of outside litigation.
And I know I said that was the last question, but your answer prompted a couple of others. So does our approval require the mine company to tell us when they commence operating under revised NOI?
I believe, if I'm remembering correctly, the operator is required to notify the division within 30 days, I believe, of commencing operations. They are not required to notify us first, but they are required to let us know within 30 days that they have begun operations.
Since this is an ongoing expansion of an ongoing operation, they have to notify us of what?
That is a good question. Since I would imagine, and I would need to look at the rule to make sure, I would imagine that they would need to notify us that they had moved into that undisturbed area. And part of that is typically associated with the fact that we require a bond before they begin any operations. In this case, the bond is already being held by the division, so that maybe is less of a concern.
So in terms of them seeking other approvals that are necessary, you heard about the litigation that is taking place. Would you assume or would you think that mining in this revised area cannot take place until that litigation is completed? Or do they have the okay to proceed at any time?
Our permit does not grant them the ability to mine if they are not in compliance with any other statutes and rules. I do not represent Geneva, but if I were their counsel, I would tell them to be very cautious about moving into that area until I had a court decision saying that it was legal to mine in that area.
Okay.
And Draper could probably specify, I faintly remember that injunctive relief was part of that lawsuit. So there might be some sort of court prohibition on entering that area until it's resolved.
So I may return to Geneva in a minute and talk about what I just asked you. But to accommodate me as the hearing examiner, I'm going to suggest a short hygiene break. So we'll come back in about 10 minutes. Thank you. Okay, thank you for that interlude. Hopefully you were all able to take advantage of it like I did. Going to make a little change in the order based on some of the things that were presented by the division. I thought it might be helpful, with the advice of counsel, to have Draper respond for just a few minutes regarding what the division said, and then we'll close this out by a rebuttal by Geneva, if that's all right. So, Ms. Wyndham, if you want to go ahead with that, please proceed.
So I understand that you are going to give me an opportunity to respond to the division's comment that they've not received comments or suggestions from citizens or from Draper about mitigation measures that might be taken, particularly to control dust, or I think that would also apply to areas that might be concurrently reclaimed by Geneva. I have two responses to that. First, I think this is where the statute's requirement of an impact assessment and the placement of that duty on Geneva is important. So Geneva should be providing, as part of its impact analysis, a scientific investigation of these significant issues that are impacting and have been observed to impact Draper. And Geneva is in the best place to suggest what might be done to mitigate or minimize those impacts, as so long as it acknowledges those impacts first. But that said, Draper would certainly like the opportunity, and potentially in continued administrative proceedings will have the opportunity to provide additional input if the division is willing to give us that opportunity. Thank you.
Great. All right, with that, Mr. Wallen, I'd like to turn the time back to you. I know you've heard a lot of statements today, and I'm sure you have an opinion on those things.
Thank you, Director Baza. I will keep my remarks short, but I'll try to address some of the points that we've heard. First, in response to the dust mitigation, we agree with the division that part of this revised NOI is the approval order, which includes a dust mitigation plan. The Division of Air Quality is the agency with the expertise on those matters, and has reviewed and approved that dust mitigation plan. And so we rely on that. We rely on that, and we think the division appropriately relies on that. So to the extent that there's a concern that Geneva has not adequately identified or adequately mitigated dust matters, we think that's incorrect, and we think they have been identified and mitigated. With respect to some of the questions regarding commencement of mining, the division's rules provide in R647-4-13 that prior to commencement of mining, the operator must post a surety bond. There's no other requirement that we are aware of from the division's perspective that would require a further notice. If you have your bond in place, the rules say that that is required before commencing mining. With respect to getting a local government's blessing or approval prior to commencing mining, we are not aware of any approval that Draper City would need to provide in this scenario. The vested mining use statute provides in Title 17-41-501 that there's a conclusive presumption of a vested mining use upon meeting the requirements of that statute, including filing of a declaration. We believe that those requirements have been met, and Draper has sued us about that. And there's an ongoing litigation matter about that, and we're engaged in that. And so we will continue to work through that litigation, but our position is that there is no further affirmative approval that would be required and that is consistent with our reading of the applicable statutes. Furthermore, as has been presented today, Title 40-8-17, subsection 1, specifically says that all other applicable laws need to be followed. And it's the division's practice when it issues an approval to describe that their approval is for the division's purposes only, and that any other applicable laws are followed. And we believe that such language is sufficient to meet the division's regulatory requirements. Again, the division is not the local government authority and does not have to enforce the local government code or ordinances. And I think it's pertinent to remember that local governments derive their authority from the state. And what the state legislature decides to give them is the authority that they have. And so they don't act as sovereigns with independent authority. They act only in accordance with the authority that's been given to them. Finally, with respect to this relates back to some of the dust and air quality concerns, but we think the division is correct in its assessment that the production limits are what they are, and the approval order doesn't provide for additional production at this site, regardless of where it's taking place on site. And that approval order considers what type of equipment and what type of emissions and what kind of dust will occur on this site, and what measures need to be taken to mitigate those things. All of those things have been discussed. All of those things have been approved. And this should not be viewed as an expansion, but because of that approval order, we are required to stay within the production limits that are set forth in that document. I know I said finally, but I have another point, which is the traffic and wind mitigation that were raised in some of the discussion. It was mentioned that we don't have sufficient facts or sufficient support. We would call the presiding officer's attention to page 17 of our brief and page 19 of our brief with respect to those issues, and we have identified those. To answer the earlier question about the load requirements, our quick research here at the table looks like it's the Utah Highway Patrol that enforces the TARP law, and it requires securing your load, covering your load, preventing debris from truck traffic, and that's in Title 72-7-409. So we hope that's responsive. If there are any further questions, we'd be happy to address them.
Thank you for that, Mr. Wallen, and I appreciate the reference to the brief that you provided. I know everybody's kind of awaiting what's going to happen next. And in order to provide you with some of those statements, I'd like to confer with my counsel for briefly. This won't take more than 5 minutes, so we'll discontinue the recording for a short period of time, and I will come right back and we'll close this out. So thank you. Thank you, everyone. First of all, let me say I appreciate the amount of effort and time this has taken to have this informal adjudicative hearing. It is informal, so the rules are not hard and fast about how we conduct business. But I think I need to applaud everyone who has participated today in doing it such a courteous and professional manner. And it helps me as a hearing officer to know that we are behaving ourselves and we're doing this as well as the state can do it. So thank you for doing that. I also want to say that each one of these is different, especially for me. I mean, I do this maybe once every couple of years. So it may be that I'm asking questions that seem obvious to some people, but it helps me to know that I'm making the best decision we possibly can. So let me tell you what's next. I will be working with my counsel to prepare an order for this informal adjudicative hearing. Adjudicative, I have a hard time saying that. But I will prepare an order, and there's a couple of options to that order that I have as a hearing officer. I can affirm the division's tentative approval of the revised NOI. I can remand it back to the division for additional analysis. And that will be determined by the order that I issue within a reasonable time. I think I said a few weeks, but within a reasonable time, but as quickly as we can do it. That order will also indicate what the rights of appeal are. And I won't go into detail about what those rights of appeal, but because decisions by the division and me as a hearing officer can be formally appealed to the board, it'll describe to the parties how to do that. So I think that's as much as I want to say about this today. We'll take this under advisement, and I think the division, you know, if it turns towards a remand, then you ought to be prepared to address that. So I thank you all again for your participation today. It's been great. I like this opportunity to hear from both mining operators and the general public at large. And please have a good rest of the weekend. Thank you so much, and we'll consider this adjourned.